afternoon. Welcome to our concurrent session, Human Dignity in Europe. My name is Clemens Sedmak, and I serve as director of the Nanovic Institute for European Studies here in Notre Dame. You can easily see a connection between the topic Human Dignity in Europe and the Nanovic Institute's mission. Before I begin, I just need to make an announcement. Teresa told me that an interpretation receiver is missing. If you have, by chance taken it or eaten it or something, please let Teresa know or return the device to its original destination. So interpretation receiver is missing. Not the interpreters, they're still alive, but the interpretation receiver is missing. All right, sometimes it pays off coming from Austria and having an Austrian friend. When we put this conference together, I wanted to invite a high-level jurist who knows the European Court of Human Rights. I asked my colleague and friend András Müller, professor of international law and human rights at the University of Basel, whether he could recommend a high-level lawyer. And he said right away, he could recommend Professor András Sajó. He also helped me to connect with Professor Sajó, and here we are. I'm so pleased to welcome András Sajó to our conference at the University of Notre Dame. Maybe a little clap of hands now. We're very happy that you're here. Thank you. You should know that Professor Sajó traveled early morning from California via Chicago, and that's shock enough. And now seeing the snow, there is even more shock. So we need to acknowledge the heroic virtue involved in this visit. Thank you again. By word of introduction, András Sajó is a former judge at the European Court of Human Rights. He has served as judge at this court for 8 years, from 2009 to 2017. He was also the vice president of the ECHR from 2015 to 2017. He's currently a university professor at Central European University, previously Budapest, now Vienna. Sad story in itself. He previously was a visiting professor and guest lecturer at the University of Toronto, Columbia University, University of Chicago Law School, NYU School of Law, Harvard Law School, Bocconi University in Milano, and many other institutions. Professor Sajó received the Hungarian Academy of Sciences Book Award and a Blackstone Lecture at Oxford University. He holds honorary doctorates from a number of universities, including the European University Institute in Florence. Professor Sajó has been involved in legal drafting throughout Eastern Europe. He has also participated and advised in drafting the Ukrainian, Georgian, and South African constitutions. He has held many positions in public service, such as serving as legal counselor to the President of Hungary, chair of the Broadcasting Drafting Commission in Hungary in 1994, as a consultant for the World Bank or as a consultant for the United Nations Development Programme. He's also a member of the Association Internationale de Droit Économique, the Internationale Vereinigung für Rechtsphilosophie, the International Sociological Association. He was also the founder of the Hungarian League for the Abolition of Death Penalty. Professor Sajó has published extensively on constitutionalism, the rule of law, theory of democracy, the secular state, human rights, and media regulation. His recent publications include the Routledge Handbook of Illiberalism and Ruling by Cheating Governance in Illiberal Democracy in 2021. I could say much more. I just mentioned that in 2020, Professor Sajó was appointed to the Meta Oversight Board, an independent body to which people can appeal if they disagree with corporate decisions about Facebook or Instagram content. He just returned from this meeting where he met our own colleague, Paolo Carrozza, who is still there in sunny California. Welcome, Professor Sajó. We have 1 hour together, a little less now. We go by the right clock and not by the left clock. So we will end at 3:30. And what I would like to do is I would enter a conversation with Professor Sajó for maybe half an hour, and then make sure that we have 20 minutes for your comments. And please make sure that your questions are concise and polite and brilliant. Thank you. I would like to start with the European Court of Human Rights. Let's assume that not everybody here in the room knows a whole lot about this European Court of Human Rights. We may know that it was started in 1959 and that the Council of Europe and the member states are the body behind it. But could you tell us a little bit about the European Court of Human Rights and its role and its history?
First of all, thanks very much for the kind words and for the invitation. It's really great place. I'm really impressed by the beauty of the campus and the building. And I hear many good news about the programs which you have here. Now, to your question. So this is a court, kind of court of last instance. So anyone who is in Europe or affected by a European measure by a state is entitled to apply to the European Court. Every individual, which is a real, used to be a real novelty in international law and in international human rights law, because generally international law is about interstate relations, but here the individual became the center. And as I say, they apply and the court has to take all the applications. We do. I apologize in advance that I will use present tense, although I don't do this anymore. But the court does take every case that is admissible, which means that, contrary to the US Supreme Court, we really have no choice. Individual human rights ought to be protected by our court. Of course, this is not a very pleasant news. There are too many human rights violations in Europe, and consequently, there are too many applications. For a court which has 47 judges, every member state has one judge.
46 now.
46, yes, I am really old school guy, and I forgot that Russia is now out, although some of the cases somehow linger still in the court, and some very important judgments recently were rendered in respect to Russia. Now, so there are applications, several thousand per year, and the court became the victim of its own success because we could not handle that huge amount of applications. So there is a huge backlog, although with various methods we try to overcome that backlog. But basically, I think the most important thing is that individuals do have a recourse against domestic measures, in particular domestic judgments. And I think that's the way it works.
I'm so intrigued. One of my hobbies in sleepless nights is to look at dissenting opinions of decisions of the European Court of Human Rights, especially Article 3 violations. And could you tell us a little bit about the dynamics of these dissenting opinions? And of course, I did my homework, so that there is a prominent dissenting opinion by Judge Sajó in the case Ferre versus Belgium. Where you said in your, it's a long, wow, I was, it was a sleepless night, I almost fell asleep, don't worry about it. But a very long dissenting opinion, a very, I mean, erudition is amazing. But you had this line in here: content regulation and content-based restrictions on speech are based on the assumption that certain expressions go against the spirit of the convention. But spirits do not offer clear standards and are open to abuse. Humans, including judges, are inclined to label positions with which they disagree as palpably unacceptable and therefore beyond the realm of protected expression. However, it is precisely where we face ideas that we abhor or despise that we have to be most careful in our judgment, as our personal convictions can influence our ideas about what is actually dangerous. That was a free speech kind of case. And my question is this: I tell my students, and I hope this is true, that the judges in the European Court of Human Rights, they are equally brilliant. I mean, some more than others. And they have the same legal training, basically, and they know the European Convention on Human Rights, but still they disagree on some fundamental questions, especially Article 3 violations, that's the dignity paragraph. And so what's the dynamic of the dissenting opinions? and what's the psychology, and how do you explain that? Is it because of personal preference? Is it because of different training, cultural backgrounds? Please enlighten us.
So sometimes this is not that much a different culture, but it's really a different understanding of the function of a judge at this level. Of course, some colleagues are of the view that only exceptionally that the court has to interfere or intervene, and they have a certain policy-related approach that you should not antagonize too much the hand that feeds you, so the member states. Others do not really care about this that much, and they just believe that human rights are what they are, and they have to be protected. And even if a member state will not obey, which happens but not regularly, what matters is to develop a standard, a point of reference, and that will be the function of the court to show the light. What kind of light you can debate, but anyway, these are the philosophies behind it. Now, there are other differences. There's nothing special in this. If you were educated in an American high school or an American law school, pretty standard by American standards, but that's not the way it is perceived in Europe. And some of us who had a training here or for some other reason were more US oriented in freedom of expression cases are of this view, and others, they are not so much fond of the United States, even if it comes to the best part of American legal doctrine. So this is one of the reasons why you have dissent. Sometimes it's really a moral issue, personal conviction. But let me tell you a story. I know
yes, please, a story.
A story is always a story. So when I became a section president, which means I was presiding in at the first level, very few cases go to grand chamber. Most of them are at this chamber level. I thought that, and this is the prevailing understanding, that we really have to go for a kind of consensus building, which I think is the correct approach. We come from different cultures, different perspectives, so try to come out with some commonality. And that means that you have to accept compromises. And this was the first case I was presiding. It was a Romanian case, ended up on the front page of Financial Times. I will not go into the subject matter, but there was a stake. And I thought that my colleagues, they were difficult. They were difficult. I thought I have to bring them together, and there was a draft. The way it works, that there is a rapporteur who prepares a draft, then we deliberate on the draft and we make changes or suggest changes. Then there is a second round, and then we vote. So the draft was awful, and I managed to make changes, so it was still awful, but I thought that if I push further, the judge, the rapporteur, will become very antagonistic, and he or she may carry the day. So at a certain point, I said, okay, it's a rotten compromise, but let's have it. It was the worst judgment ever I signed. It was the first one. And it was not very well received, as the front page indicates. And it was technically a mistaken case. It should have been thrown out. And first I tried to mention that, but the others really wanted to say something important. So I gave up on that. And then I realized that really you have to move towards compromise, but there ought to be limits, because at a certain point, the compromise goes to the detriment of logical clarity and at a certain point even to values.
Or the victim, yeah.
So that is something that.
Can you tell us a little bit what happens off stage? So yesterday in my diplomacy class, we had a virtual visit by Heidi Evans, who works at the United States mission to NATO in Brussels. And she said the most important elements of the negotiation happen in the coffee shop, not around the negotiation table. How is it with the judges? Do you get to know them better? Do you go out for dinner?
So the culture is that we really have to develop a community, and there are social conventions that we invite each other, but we have certain limits on to what extent you can discuss cases outside the deliberation room. There is a process, a written process where you comment, and you can of course always ask clarification, but it's not considered proper to get together face to face with one or a couple of judges and discuss the case specifically, because that would create, certain antagonism. So if you disagree, do that either in writing, which is accessible to all, or do that in the deliberation chamber.
And there would be no space where you can talk about fundamental issues such as how do you interpret Article 3 violations outside of a particular case?
We had a formal program for a while where certain new developments in international law were discussed, or how national courts react. This type of thing we had. Again, specifically on what the convention says, or what we think generally, that was for deliberation, not for this more abstract academic type discussion.
So it's taken for granted that people have a sense of the convention and they work with what they
No, well, frankly speaking, this is a very simple convention, really short, not particularly complicated. What makes it complicated that you have 50,000 judgments that you have to keep in mind in order to apply those 4 pages or 5 pages of document.
I have no idea how your judges do it, but you have the bureaucrats, right, that help with that.
We have clerks, but the way we work is basically, some people have great memory, first of all. They are really great. I'm not one of those. And so what I do, I always use a computer system, and that helped a lot. I don't know how people could do this without a computer. It's difficult.
Let us move to the question of dignity, since our session is on human dignity in Europe. How would you see the way the European Court of Human Rights and its decisions have shaped our understanding of human dignity? What were milestone cases?
Yeah, well, I have to emphasize that the convention does not mention in its original text dignity. There is one amendment to it where this comes up, but it is not part of the foundational text, which is very strange because this was written basically in reference to the Universal Declaration. And there is very little travel preparatoire on this matter. So no one knows why this was left out. I guess the Brits didn't like it. It was, well, that's enough.
Let's see what happened to that.
Yeah. So there are tons of cases. I just seen statistics, although it's not a good one, that 2,000 or 3,000 cases contain it. Why this is probably exaggerated, because very often only the applicant is who refers to it. But it is used to some extent. Again, let me tell you, you wanted me to tell the backroom stories, right?
Yes.
So I recall that this is used as an argument when you really would like to silence others, or you would like to silence a state. this is ultimate idea. It is really inconvenient to argue against dignity. Now, having said that, the legal concept is not clear. So just to give you an example, in assisted suicide cases, in a case called Pretty versus United Kingdom, exactly, poor lady was denied. She could not really commit suicide. Terrible suffering. And she wanted her husband to help, and she wanted assurance from the prosecution in the UK and in England that he will not be prosecuted. And this was refused, and the case came to the court, and the court basically said, yes, this is a matter of dignity in the sense of self-determination. So that's one of the understandings. And then they said, yes, but that's not enough. And in another case, the issue was frozen embryo, not embryo. It was just the sperm. Yeah, or maybe it was embryo. Embryo, yeah. And then the court again recognized that this is a matter of self-determination. And again, they said, but it doesn't matter. There is no right related to that in that context. So it varies enormously. Now, this seems to indicate that this is not that important, that it doesn't carry the way. The reality is a little bit more complicated and perhaps more favorable. So there's a general recognition that dignity lies behind all the rights. It's not contested, but it's just an ideological statement. But there are very pragmatic rules, specific rights in the convention, or the way the convention is interpreted, which basically provide sufficient protection to dignity, in particular when it comes to prohibition on torture, inhuman and degrading treatment. There is one definition offered by the court which says that basically when the state or where the state imposes suffering that is more than necessary in prison conditions, in this case, then this is a violation of dignity. And this is why what would be in the US cruel and unusual punishment is not acceptable. Again, how this is translated into practice. We had a case concerning prison conditions. The European, there is a special group in interstate group that provides various suggestions to states. And their idea was for a very long time that a prisoner is entitled to 6 square meters in prison. The European court never accepted that. Finally, they said 4 square meters is the minimum. Other than that would be inadequate, improper treatment. Again, the background being dignity. And then we had a grand chamber case. You remember this is the kind of appeal court which only exceptionally accepts a request, where the majority ruled that all things considered, 3 square meters will do. Now, I thought that this is really the opposite of what human dignity means, not just because 3 meters are really, I try to imagine, I visited prisons, not that I didn't know what I am imagining, but I just tried to imagine life. And this was just unacceptable. what was really troubling, that the court said that the court didn't really look at this. The court, or the majority, was of the view that, okay, we know that this is not very comfortable, but you can go and play basketball. That was offered to the prisoners. And so this is bringing a person out of this condition. So they realize that this is undignified, but they say it can be counterbalanced. Now, in that specific case, the applicant was 72 years old. Maybe he enjoyed watching basketball. I don't know. It was not part of the, it was not on record. So I'm not sure that the opportunity to play basketball at the age of 72 is capable of undoing so again, dignity is the underlying concept. It's used as an absolute trump. I used it, I remember, once, and I got the judgment as I wanted, because others were afraid to say that this is not, but you know, that's not exactly what dignity is about.
So I hear three things. One is dignity is a conversation stopper.
Yes,
Peter Birnbacher talked about
exactly.
That. Secondly, dignity in the European Court of Human Rights is connected with self-determination and the avoidance of unnecessary suffering.
Right.
And thirdly, there's a certain arbitrariness in how to enact that.
Right.
And brings me to two questions. One is, do you think that there is a specific European understanding of human dignity where, let's say, our institute here is the Nanovic Institute that bridges Europe and Notre Dame, that we can bring as useful lessons to our American friends? That's my first question.
In some cases, you sense a certain Kantian self-determination idea. Autonomy is very important in a number of cases. So the principle is there, but as I mentioned in the Preti case, it does not always carry the day. Again, I think that that was a very tragic judgment. It was a very difficult case, morally, I would say. But it's also very important that you can see at least the flag. So the concept is there. And when something operates as you mentioned, as a conversation stopper, you can't stop conversation too often. So if there is anything to learn from the European experience, that is that use it with caution.
Yeah, and that brings me to my second question about this arbitrariness suspicion. So I remember the Sajó versus Germany case. Where you had a person suspected for drug trafficking. He was observed doing something. They couldn't find any drugs on him, but they observed that he swallowed something. He refused to take a medication. Then 4 police officers basically held him down, and he was forcefully, inserted a medical device that made him regurgitate, and it was cocaine coming up. Anyway, and the big debate was the threshold of severity. Have we met this threshold? And my question is, what are the criteria to decide whether the threshold of severity has been met? Because the judges didn't agree at that point.
No, and I think they won't agree today either. But what is important that here you also have the idea of what is more than necessary suffering. And secondly, again, I mentioned already Kant, and this person was used as an instrument to get the evidence out. So his body was just an object, an object where you can find something. And I think that was very important in the finding or in the conclusion that this is against dignity. It's one of the few cases where the majority insisted that this is a matter of dignity.
Since you mentioned Kant, what I as a philosopher and not a lawyer find so fascinating that sometimes the judges use really philosophically inspiring language. And I give you 2 examples, and then I ask you whether you would have anything to add. One is from this case, Winter versus United Kingdom, about the lifelong imprisonment, where the person had no option for a parole. And in a concurring opinion, Power 4, they said, Article 3 encompasses what might be described as the right to hope. This is beautiful. I mean, my heart was warmed when I read that. And he said, long and deserved though their prison sentences may be, they retain the right to hope that someday they may have atoned for the wrongs which they have committed. They ought not to be deprived entirely of such hope. To deny them the experience of hope would be to deny a fundamental aspect of their humanity, and to do that would be degrading. So I thought this is a deep philosophical thought, the connection between dignity and hope. And the other example is, I hope I find that, from the Bouillet versus Belgium case, where a police officer was provoked by a 17-year-old at a police station and just hit him once. And the judges said, and that was in the judgment, it was not a concurring dissenting opinion, a slap has a considerable impact on the person receiving it. A slap to the face affects the part of the person's body which expresses his individuality, manifests his social identity, and constitutes the center of his senses, sight, speech, and hearing, which are used for communication with others. So they make a point of the face as, like Levinas, as the center of human identity. So these are two deeply philosophically inspiring thoughts.
Well,
Professor Sajó.
Well.
I like those.
No, I must say that that the right to hope. By the way, she was very much, or she is very much influenced by Catholic philosophy. So she,
okay,
that's yeah, she is really the one. This Paulo Pinto de Albuquerque. They were the two who were really inspired by this. I agreed with her, but it was her opinion, so I didn't want to interfere. Now, the truth is that the then secretary, the Home Secretary in Britain said that not in my lifetime. I promise you that that these people will never leave the prison. And then in the next case, the court basically said it doesn't matter. The British system is now so wonderful that we will accept. So they did not carry the day.
Yeah.
And as to the philosophical, yeah, so the philosophy is sometimes there, but it doesn't carry the day, I'm afraid.
Yeah, I've heard that before about philosophy.
Yeah, right. Well, but at least we do not end up like Plato, so working a little bit as a slave.
What you mentioned about the United Kingdom is one of the challenges of the court, isn't it? That sometimes you get resistance from the states. So there's the backlog issue, and then there's the resistance of the states. And David Cameron, didn't he say at some point a judgment made him physically sick? And I think it was the judgment about the voting rights of prisoners.
Yes.
So how did you deal with that? And then we are moving into my last topic, Europe, and the state of human dignity in Europe.
Yeah.
The resistance from the states.
That is, if it were in a national system, everybody would be outraged. And by the way, this he said about our court, and it had an impact. Because financially, the whole system depends of member states. Russia was very much encouraged, but the Brits said, and so it had repercussions. But then there was a recent judgment of the former House of Lords, so now Supreme Court of the United Kingdom, and the British press did the same to the British judges. And that was something unheard of. And that resulted in a certain backlash in the United Kingdom. So it is dangerous. It really undermines respect to the or belief in the judicial system. So you first you go against a weak entity, and then you go against your own, and then you will see what happens. It's a cascade.
Which brings me to my last topic I want to cover. That's Europe. So when we designed this session, that was before the Russian invasion of Ukraine, and now the whole situation of talking about dignity in Europe is framed differently. May I ask just this general question? If I were to ask you human dignity in Europe, what comes to your mind?
Well, I would say that a certain, the fundamental belief that whatever it means, there is something to be respected, that survives. It is very clear that public opinion was very, so we can look at this at two levels from the perspective of international law, with aggression and clearly prohibited by international law, and so it's not a big deal to say that this is unacceptable, right? But that was not the crucial thing for the moral perspective. The decisive thing was Bucha, the very high likelihood that inhuman treatment, war crime, even worse, occurred. That was what really had an impact on, and still has an impact on, public morality. That won't work without an underlying fundamental belief in dignity. So I think that as long, and by the way, I lived 40 years in a regime that was under Soviet occupation. And I was drafted, and then I worked as an interpreter for the Hungarian army, Russian-Hungarian. So I had encounters with the Russians, a very nice guys, so drunk all the time. But it was very clear that one thing that is characteristic, they didn't value human life too much. They were very wholehearted and friendly, but if there was suffering or death, it was not that important, or somehow they had a different approach. Now, I don't want to generalize, but there is an element of this, that you just don't care about the life of others, including the life of your own community, members of the community. So I'm not saying that there is no respect of human dignity among Russians, don't misunderstand me, but it's slightly different.
Do you think,
and so I see here a difference between the understanding of dignity in most countries in Europe, and one of the sources or one of the causes of what is happening, caused by Russia.
Do you think that there is a difference between Eastern European and Western European states? Because I'm from Austria, as you know, and our big reference point is the Shoah. So that's the big reference point, and not the trauma of communism. Do you think that that makes a difference in having the instincts about human dignity?
I think that what is mostly, there are two approaches to what Eastern Europe or the eastern part of Europe is, because East Central Europe, so from Poland down to Bulgaria, they believe that although they are on the east, but in terms of value, they are part of the Western community, or at least that's one prevailing idea. It is contested, but it's there. And then you go to Russia, and they also had this debate, where do they belong historically? But it seems that they're much more, we are different. That's what prevails. So it is not so easy to say where this difference begins geographically.
That's for true. I just thought that the experience of communism may create different reference points when people think about dignity.
I think that is the unfortunate thing is that it's not so much the experience of communism, but the way countries or people in Eastern Europe refer to Nazi wrongdoing. because contrary to Germany, and partly because they were occupied by communists, there was never an understanding of national responsibility for genocide, or even for participating in the war and committing war crimes. They never accepted that fully. And that makes the difference, not because their main concern is communism. In Hungary, it doesn't matter at all, by the way, today. They are friends of Russia, notwithstanding the presence of the Soviet army for many years. So I think this is the crucial thing, that the denial of some evil in their own history.
Yeah, which also means the ethics of remembering and our understanding of dignity are deeply connected.
Yeah, that makes a difference.
18 minutes, friends, if you have any questions. I see Dean Appleby first, our lady here, and then our colleague over there. Yeah, but Scott, it's fine.
Okay, I was going to say, I'll ask this question while others are considering their brilliant and succinct questions. I'll ask a different kind of question, not brilliant or succinct. But it's about the question of precedent, stare decisis. This is work in the European Court of Human Rights. Who sets precedents that might be followed by other judges? Is it at the level of the cases you have been ruling on? So how does it work? And then the second follow-up question, if the answer is yes, there is a strong a strong principle of precedent, and it rests within the European Court. Can you look back? You've given us some of the great concrete examples of different cases. Can you look back at a couple of cases where you may rule, or whether dissenting opinion or otherwise, and you felt like you helped to set a precedent, maybe around the question of human dignity in some way, that makes an inroad in a certain direction legally in the European Court?
So there is a very strong belief in precedent. There ought to be exceptional reasons to depart from precedent. Nevertheless, with this amount of cases, and because there are two languages used, you can always find two lines of precedence if you wish, and then you can play around. But the fundamental doctrine is that we are a precedent-bound court. And there are certain criteria, as I mentioned, where the court that would like to depart from precedent has to justify it. The fundamental doctrine of justification is that the convention and the human rights system the convention is a living document. So you have to adapt to various changes. Two quick examples of how precedents are used or disregarded. One, the convention, again, probably because of the Brits who had an important role in the drafting, the convention does not have a provision which allows access to information. And there were precedents in conformity with this idea. And then gradually little creaks appeared in this line of precedents. And finally, the Grand Chamber, which is only entitled to change the precedents officially, the Grand Chamber said that it's true that there is no such right, but you can derive that from freedom of expression, because freedom of expression under the text entails right to be informed. And if a certain information is already available because the state has prepared it for its own purposes, then there is a right to have access to it. So this access to information was created in this respect of previous precedents. The very bitter dissenting opinions were written to that. The other example, you asked about my own personal experience. I thought that the court is a little bit moving away from a very high level of protection in certain areas. And in a number of cases, turned out that I am the most conservative judge in the sense that I insisted on the existing precedents, which offered a higher standard of protection. And the court moved away, said that, for example, that fair trial is not that you have access to a lawyer from the moment of detention or first hearing at the police, but you have to look at the totality of the procedure, which I couldn't disagree more. It doesn't matter, but we had a very clear precedent that this is not okay, and they moved away under this. So
you did not prevail in that case.
do I look like someone who prevailed?
Thank you, the lady, our colleague here. Thank you. Just start talking.
Okay,
Yeah,
now you can hear me. So I was born and raised in Italy, so I'm more familiar with the impact of the court in my own country. And my country is one of the cases that show this resistance of states to the decisions of the court. So despite them being legally binding, it might take even a decade for these decisions to be implemented. So in your opinion, in order to ensure a better compliance with these decisions and a faster one, especially, should pressures come from below, from civil society, both at the domestic and European level, or from above, namely the Council of Europe, for instance, through threatening sanctions?
Unfortunately, the Council of Europe has no means to apply sanctions. They could shame to some extent. They publish which judgments were executed, which were not. That doesn't have much of a shaming effect, unfortunately, especially when non-execution is becoming common. So that is a problem. But again, it's a matter of what is the function of the court? If the function of the court is to set good, high, and effective standards, that gives ammunition to local civil society. And more than that, even a judiciary in a country is divided. Some are more progressive, more human rights oriented, others are less. And this is an ammunition for them. It's an ammunition for the lawyers. They can refer to it. It's embarrassing for a judge to hear that what he does is clearly against European norms. So it can be instrumentalized, if you wish, and that helps. So yes, it's a problem that there is non-enforcement, although very important cases were enforced. Let me give one example, which, by the way, at the end of the day, that was the case where I dissented at the end. But so this is what happened. In a Turkish case, the court ruled that there was no defense lawyer after the arrest of a person, and there was a police interrogation in the absence of the lawyer. Court said this is not acceptable. The Turks, after a while, changed the law, but that's not the interesting part of the story. In France, they changed the law too, because they wanted to avoid embarrassment. More importantly, in France, this was a 200-year-old battle between the police and the Bar Association. The Bar Association, understandably, wanted to be present, right? The police didn't want. And at that moment, the Bar Association got an extra card in its hand. And that made the difference. So there are many ways the judgments can be efficient, even if a specific judgment is not fully executed.
Thank you. A question over here, and then Annibal, but first our colleague to the left.
Thank you, Professor Sajó, for being here. It's a really pleasure to hear European perspectives of human dignity. And I have a concise and polite question, as Professor Sedmak asked. In one work, you wrote that concept of human dignity can have like a liberal tendency or even somehow threaten the freedom. Could you clarify this idea, maybe on some examples of cases in this regard?
Yeah, so first of all, thank you for the protection you tried to.
Yes, everything for you. You came all the way.
Although it didn't work perfectly well, because there's a very...
Look at me, yeah.
So I think that dignity can be used for paternalistic intervention. That's basically what I have in mind. That individuals are considered to be in need of constant patronizing. And they are told what kind of autonomy they would like to have. So this I think is the dark side of dignity-based jurisprudence. It embellishes this kind of paternalism.
This is interesting because the Keough School of Global Affairs, that's the one that invited you, with our dean here. Our defining slogan is integral human development. And we sometimes face similar suspicions. Is there a moment of patronizing in the term? And who gets to decide what is IHD and when do we violate a person's dignity? So that makes a lot of sense. Professor Anibal.
Thank you for the wonderful presentation. I wanted to ask about illiberal regimes. We have seen the emergence of illiberal regimes in Europe in ways that were unexpected or unthinkable 20 years ago. And my question is, what is it that a court like the European Court of Human Rights can do to address the problem of the emergence of illiberal regimes, and how effective can that be?
There are now, let me be a little bit more specific. So there are different forms, and some forms are not observed, others are observed too late, and some got already the proper answer. Where I think there was not sufficient reaction. This is how the Turkish government operated even before the putsch. After the putsch, there were mass arrests, judges, journalists, teachers, thousands of people, and the court basically said that the Turkish government invented an administrator who will review these detentions, not a judicial authority, and one single person for 16,000 people detained. And the court said, okay, this is a remedy to be exhausted. We will not deal with those detentions. That's not an ideal reaction, especially where you have very clear precedents that there ought to be a judicial authority to review detention cases. Where the court reacted, but belatedly, that's the Polish example. Now the court is of the view that basically the Polish judiciary or parts of the Polish judiciary are not satisfying the criteria of what is in the language of the convention, a tribunal, an independent tribunal, a tribunal established by law. That's the language. So the judgments there are not judicial judgments. The difficulty is that basically the Human Rights Convention, and I started I think, implicitly praising the convention for that. It's about individual complaints. So the only thing the court, the European Human Rights Court, can say that a judgment rendered in all these cases is void. But we don't have the power to say what shall be done about those courts. So that resulted in a new paralysis, because potentially we have several 100,000 Polish cases which were decided by a body that is not a court. So then what are we going to do with 4, 6, who knows how many 100,000 cases? Because everyone now could come from Poland to the Strasbourg court saying that, look, I was convicted for murder. Yes, I'm a murderer, but I deserve 5,000 euro because the trial was not fair. So this is the problem.
I mean, from a European perspective, what is also disconcerting is that people openly confess that they are illiberals and Democrats. In an interview, you were asked about the term illiberal democracy. And you said, well, the mastermind of that would be Viktor Orban. And he explicitly said, but what we have and try to do is to build a democracy for reasons that, you know, EU money or whatever, but illiberal, and that's a positive term. And of course, that concerns us a little bit. And where does this come from?
There is one more element. And yes, you are right, that is very unthinkable. It was unthinkable 20 years ago. It was not unthinkable, let's say, in 1950, when Hannah Arendt and Keough and others wrote about another aspect of this, which was a kind of irrationality, in the sense of accepting statements which are not true. So living in untruths. Václav Havel had this line about communism, living in lie. This is something that you find in Hannah Arendt as central, really central for illiberals, that people just accept a pseudo-reality. And this is really the source of power, or one of the sources of power of these illiberal regimes, from Turkey to Venezuela to Hungary to Poland, that they impose a pseudo-reality, and that people are happy to accept.
And since we're running out of time, what went wrong in Europe, and what should we do? Crisp, brilliant. Something went wrong. This is the one. I promise this is the one.
I think what went wrong is that somehow at the institution level, there was not enough protection against these things. More deeply, and of course, because of very unexpected happenstances, stars were not properly aligned. What was in the spirit already, and you mentioned my quote on spirit, but I think in the spirit in Europe, there was something waiting to come out, and it came out. And that is not the best part of humans, what came out. It was repressed, and now it found that it is legitimate.
Yeah.
Hatred, disrespect, lying, all this was not culturally acceptable. And suddenly, these new powers, which came to power more or less through democratic elections, one cannot deny that liberated this, and live now upon that liberated force of what is negative in us.
Just, I mean, there's another panel where Professor Sajó will be on it, and that's why we can end on this rather bleak note. Otherwise, it would not allow that. Thank you so much, Professor Sajó.